Wolf Theiss Soundshot. Insights and analysis from one of the leading law firms in Central, Eastern and Southeastern Europe.
On behalf of the Wolf Theiss Disputes Practice Group and in particular of the arbitration team, I am very grateful to welcome two distinguished speakers to our podcast today. The topic is climate change and the COVID-19 pandemic and their effects on legal and practical aspects in the field of international arbitration and litigation proceedings. One of our speakers is Niamh Leinwather, who is the newly appointed Secretary General of VIAC, the Vienna International Arbitral Centre attached to the Austrian Federal Economic Chamber. Niamh is a lawyer admitted in Ireland and in Austria and has an impressive track record in international arbitration with international law firms. Our second speaker is Christian Koller, Professor for Civil Procedural Law at the Institute of European and International Civil Procedural Law with the University of Vienna. Christian is specialized both in arbitration and civil procedure and has, apart from his academic qualifications, also vast experience in the practice of international arbitration. So, as mentioned, our topic today is the COVID-19 pandemic and concerns on climate change and environmental protection. These two developments have enhanced the need for and the actual use of digital means in legal proceedings, both in arbitration and in litigation, due to the often international setting in arbitration proceedings, with parties, legal counsel, arbitrators, and other service providers from different parts of the world. The practice of international arbitration has become somehow a pioneer in the application of such digital means. On the other hand, we have also seen developments for, quote, greener arbitration. That means the concerns for environmental protection in view of the needs of international arbitration. I would like to start with more wider perspective and would like to ask Niamh about the so-called Green Pledge, to which, among many other institutions, also VIAC has committed.
Thanks, Valentina, and thank you for the invitation to join the podcast. I think it's a fantastic initiative on your behalf and on Wolf Theiss's behalf. So really happy to be here today. As regards the Green Pledge, maybe before I start, I'll just say that it's important to note that VIAC as an institution is a very forward-thinking, innovative and modern institution. And this is, of course, reflected in our rules and the way we approach international arbitration. So in an effort to promote greener and more sustainable arbitration, VIAC signed the Green Pledge, an initiative of the Campaign for Greener Arbitrations. So maybe for the listeners, the Campaign for Greener Arbitration seeks to raise awareness about the environmental impact and the carbon footprint of arbitration and strives to promote more sustainable solutions. So one of the campaign's guiding principles is the commitment to correspond electronically in order to reduce paper waste. VIAC has joined close to 100 institutional supporters in promoting more sustainable arbitral practice. And maybe a nice little anecdote on greener arbitration. The steering committee of the Campaign for Greener Arbitration conducted a case study about a medium-sized international arbitration. So the value was about $30 to $50 million to determine the individual carbon footprint of an arbitration proceeding. Naturally, several assumptions had to be made in this particular case, but the result was that the total carbon impact in kilograms of CO2 of the arbitration used in the case study was 418,531. So that would actually require planting more than 20,000 trees to offset the emissions, which relates to 4 times the number of trees in Hyde Park or all of the trees in Central Park. So I think that makes it very clear to us how necessary it is to move forward with greener arbitration.
Thank you for these impressive numbers and examples from the practice of international arbitration. We see there is definitely a need for a paperless management of the files with arbitration institutions, as well as an enhancement of digitalization in the proceedings. With the background of the Green Pledge of Arbitration, has WIAG implemented new provisions with regard to environmental protection and climate change.
Exactly, Valentina. The rules were renewed last year with exactly these issues in mind. So both sets of rules. So we have on the one hand, Vienna rules of arbitration and mediation. And then on the other hand, we have the WIAG rules of investment arbitration and mediation. And both of these sets of rules reflect digitalization developments in international arbitration. And there's maybe 3 points that I can summarize here. So the first point is that WIAG has switched its case management to an electronic file management and communication platform. So in March 2021, WIAG introduced the WIAG portal, an online case management platform hosted on HiQ, a cloud-based file sharing and collaboration software that's operated by Thomson Reuters. So the WIAG portal can be used for all types of WIAG proceedings, for communication between the WIAG, the parties, the arbitrators, and third-party neutrals. And it's set up essentially to increase efficiency in WIAG cases, to enable transparency among case participants, and to address the participants' ever-increasing needs for data security, for confidentiality, but also for privacy. The goal is that we have purely electronic file administration. Of course, there are a few exceptions to this that are necessary for legal reasons. My second point, as regards digitalization, relates to conducting oral hearings in a virtual format. So the 2018 rules, our old version of the rules, did indicate that virtual hearings were possible. But now in the new rules, we have explicitly stated that oral hearings may be conducted in person or by other means. And by other means, we mean video conferencing technology. And of course, it's for the arbitral tribunal to decide in the individual case, taking into account the views of the parties, whether or not the parties agree to have a remote hearing. My third point, taking into account the increased use of video conferencing technology during the pandemic, Article 36 of the new rules provides the Secretary General, if it is impossible or feasible to send the award in hard copy form within a reasonable time, or if the parties agree, the award might actually be sent in electronic form. Now, a copy of the award in hard copy form will be sent at a later stage in order to ensure enforcement of the award, because there'll always be a risk that courts in certain jurisdictions wouldn't accept a copy of an electronic award as what we refer to duly authenticated original award as per the New York Convention. So I think that kind of summarizes, Valentina, the main digitalization measures that we have taken at WIAG.
Thank you, Niamh. Apart from the electronic file administration and the paperless communication, you have dropped an important keyword, which is virtual hearings. And since we are here in Austria, we would, of course, like to mention that the Austrian Supreme Court has, as one of the first Supreme Court, rendered a decision on the legal aspect of holding virtual hearing in the context of arbitration proceedings. In the decision of 23rd July 2020, the Supreme Court said that holding a hearing by video conference does not violate the right to be heard under Article 6 of the European Convention on Human Rights. However, the court, as I understood, also stated, amongst others, that this provision under the European Convention of Human Rights not only guarantees the right to be heard, but also guarantees an effective access to legal remedy or access to legal justice. This access could be restricted if, for instance, due to a pandemic, proceedings cannot move forward and cannot be brought to an end. Is this landmark decision only relevant for arbitration, Christian? Or could this landmark decision also be relevant for litigation before state courts? And what is the implication also before the background of the COVID-19 pandemic that we are experiencing currently?
Thank you very much, Valentina. Thanks also to Wolf Theiss for having me today. It's really a pleasure to discuss these highly relevant topics with such distinguished colleagues as the two of you. I really appreciate that. The decision you mentioned is a quite interesting one. And as you aptly put it, I think it put the Austrian Supreme Court on the map, not only among moot participants, because this was the main issue of the William C. Wismuth's previous problem, but also internationally. I think the Austrian Supreme Court paved the way for many tribunals out there to decide on a more firm basis that they really have the power and discretion to order remote hearings. Now, is this decision only relevant for arbitration? I don't think so. I think it's in its core reasoning, it's also relevant for state court proceedings for two reasons. The first of one being that the mere fact that a tribunal or court orders remote hearings does not as such entail a violation of the right to be heard, or on more general terms, as the Supreme Court also put in that decision, on the right to a fair trial. So the mere fact that people cannot meet in presence does not affect these core principles embedded in Article 6 of the European Convention on Human Rights. The other interesting aspects when we talk about the more general impact this decision has is that particularly in times where it's impossible to access state courts being present, where the access to justice can only be guaranteed in a virtual setting, I think this is where this decision really is of significance also for state court proceedings. What this decision also shows is what state court proceedings can learn from arbitral proceedings when it comes to flexibility and power to guide proceedings in the hands of the arbitrators or the state court judges alike. So I think this is where this decision is really, really important also for the future.
Thank you, Christian. If we listen to stakeholders coming from the court side, from the state side, the usual counter argument is that the principle of immediacy, so the principle that the court and the judge should gain an immediate and a direct impression of the credibility, for instance, of witnesses, but also of experts. This counter argument is often ventilated, and I was wondering whether this argument would only apply to court litigation or not also to arbitration proceedings.
I think, and this, I would also be interested on your views. This is something I think everybody has an opinion about, because this principle of immediacy is something we all sort of miss these days, because nothing is immediately before us. We all live in this now remote world, and of course, it's something different if you have a drink with a friend via Zoom or if you have a drink with a friend in a bar. This pretty much shows the effects the principle of immediacy can have. And I think all of us have a sort of gut feeling that isn't it something different to hold a hearing in a virtual setting, and isn't that principle affected? Well, I personally, judging from the experience I have, I think it is in a way different. But the core question is it different also legally? And this is, I think, where we lack empirical data. We have this very abstract concept of principle of immediacy, but we don't have real studies showing that the human brain interacts differently or absorbs information in a different way in a virtual setting. And this is, I think, what we still would need. There are books out there written from a completely legal and civil procedure perspectives, who at the very first chapter put a disclaimer saying, well, but we haven't analyzed this, from the psychological, from the empirical side of things. And I think this is something we still need to undertake before we can seriously argue that there is a difference. Now, if we tackle this problem from a more regulatory perspective, what the Austrian legislature did, it avoided this entire discussion already years ago when it adopted Section 277 of the Austrian Code on Civil Procedure, which allows the judge, in cases where there is a broad distance probably to be overcome, it allows the judge, instead of hearing evidence through a requested judge, to conduct a direct taking of evidence using technical equipment. In other words, when you look at the wording of this provision of section 277, the Austrian legislator treats taking of evidence through technological means of communication as an immediate taking of evidence, and thereby avoids this discussion whether this is in accordance with the principle of immediacy or not. I fully agree with you that if you argue this is a valid concern, it applies both in arbitral proceedings and state court proceedings, because we cannot see this principle of immediacy isolated. It's very much connected with other core civil procedure law principles which also apply in arbitration proceedings, the most important one being the free evaluation of evidence. And this is where you cannot distinguish between state court proceedings and arbitral proceedings. And if you follow those critics, the same critical assertions also apply to arbitral proceedings.
Christian, this is interesting, and it's particularly interesting that you refer to an existing provision of the Austrian Code of Civil Procedure governing civil proceedings before state courts. I repeat your reference to section 277 of the Code of Civil Procedure, because as we all know and we are aware of, there have been special provisions for this COVID-19 pandemic, and there have been provisions also in the Code of Civil Procedure which explicitly allow remote hearings. However, these provisions are time-wise restricted to June 2022 in view of the COVID-19 pandemic. And as far as we are aware of, the explicit draft provision that was originally submitted by the Ministry of Justice has now been cancelled. So there is no draft provision on remote hearings, as it is already embedded in the COVID-19 legislation. So I was wondering whether the Austrian legislator, despite section 277 of the Code of Civil Procedure, is still hesitant to allow remote hearings or virtual hearings in a very general manner for more or less all kinds of civil proceedings.
Well, yes, I think the Austrian legislator should have followed the approach taken by VIA and implement a special rule for that. And to be quite frank, I was really surprised when I saw that this specific section was still contained in the draft submitted by the ministry, later disappeared in the course of the discussion. Now, I heard rumors why this provision was dropped. I don't know whether these rumors are true, and I don't know whether it's wise to spread rumors I heard through your podcast, but I take the risk of being criticized for that later on. The rumors I heard was not so much that the content of this provision was a problem or the principle of immediacy, but rather that there were concerns that the court fees and the fees that are paid to the lawyers for attending virtual hearings would be too low. So there was some opposition apparently from some stakeholders, and this was one of the reasons why this provision is not contained in the legislatory draft we see today. Now, I think it will just be a matter of time until we will find a similar provision in the Austrian Code of Civil Procedure. And this is because in December 2021, the European Commission submitted a draft proposal for a regulation on the digitalization of judicial cooperation and access to justice in cross-border civil, commercial, and even criminal matters, and amending certain acts in the field of judicial cooperation. And this proposal, of course, is only restricted to cross-border cases, but it will give the Austrian legislator another opportunity to regulate virtual hearings in a broader fashion. When you take a look at chapter 4 of the proposal I was just referring to, it specifically deals with hearing through video conferencing or other distance communication technology. And I think the approach taken in this Article 7 is very similar to what we see in arbitration. So there we have some cross-virtualization, so to say, between arbitration and state court proceedings, because it gives the court discretion to let parties that are not situated in the relevant forum the possibility to participate in proceedings by using video conferencing. But it also gives the court discretion to deviate from the virtual hearing approach if it considers it to be not suitable for the relevant case. So I think this is a very reasonable approach to give much discretion to the judge deciding the relevant case or to the arbitrator alike to order remote hearings or to allow virtual participation if the circumstances speak for it. So, and in that case, coming back to the ministerial draft that was submitted last year, in my personal view, it was too restrictive because it didn't give enough discretion to the court. It made the admissibility of virtual hearings dependent on the consent of the parties. And I think this would be too restrictive. I think this draft will force legislators on a European scale to think whether the provisions they enacted in the wake of the COVID-19 pandemic are there to stay, so to say.
This is interesting, Christian, that you mentioned the European law perspective and that European law, as in so many other instances, might be a driver for further developments on the national level. Christian, you have also mentioned that we somehow lack empirical data on the impact of virtual hearings or remote communication, but maybe arbitral institutions such as the VIAG can help us out on that, at least with regard to their experience and what they see with regard to virtual hearings. My particular question to Niamh would be, what are your learnings from virtual hearings that you see in your cases, in the cases administered by VIAG? And maybe you would also have some numbers that you would be able to share with us.
Thanks, Valentina. I would obviously love to be able to present a lot of empirical data, but unfortunately I have to disappoint. We don't have exact statistics on the number of hearings that are held virtually, but I would say from our experience that it's been about half of the hearings that have been held virtually since the beginning of the pandemic in March 2020. I get the impression that parties do have, however, a preference to in-person hearings. Maybe that's a developmental aspect whereby counsel have to develop new skill sets in order to hold a hearing virtually. There are different aspects that need to be taken into consideration, like lengthy testimony doesn't translate well in an online format and all these other aspects that need to be considered. From an institutional perspective, our input is actually limited in that these are issues that are usually discussed between the parties and the arbitral tribunal in the case management conferences, where the institution is obviously not privy to those discussions. We have been asked by parties for practical advice when it comes to hosting their virtual hearing, and the VIAG put together what we call the Vienna Protocol. It's a practical checklist for remote hearings. It's available on the website and it gives parties, counsel and tribunals a few pointers as to what they need to consider when they are conducting a remote hearing as opposed to an in-person hearing.
Apart from the aspect of virtual hearings and remote communication, let me get back to the paperless file and the electronic file administration. Even prior to the COVID-19 pandemic, the Austrian court system has increased the use of digital technology, for instance, by introducing the electronic file, by the electronic transmission system between legal representatives and courts. This is a question to both of you. Do you think that this will be the future for all kinds of court proceedings, including civil proceedings in marital and custody matters, or even in criminal proceedings? Or would there be legal restrictions in view of the guaranteed access to justice? And could any possible gain as to the carbon footprint outweigh any legal or procedural considerations? What is your view on that?
I think this trend will continue, this trend of digitalization, of using modern technologies in the course of civil proceedings in general. And I think it will not stop at what we see as straightforward litigation, but it will also continue to affect other areas of law, as you mentioned, like marital disputes and so forth. However, there always needs to be safeguards that the access to justice is guaranteed. But when you talk to people who really engage in how technologies can develop, there is often the argument that using more and more technology will increase access to justice for people who are currently not on a European level probably, but if you talk about it on a global level, that this will increase access to justice, because nowadays most people have a smartphone and use it for all kinds of things. So it would be the logical step to develop certain applications that allow you to access the court via your smartphone or via certain communication applications you have on your smartphone. So I don't think that this is something restricting access to justice. I think it can be the other way around.
I think this is definitely the way that we're going, and I think it is a positive development for access to justice. With one of the main safeguards for me being the security aspect. I know from our experience with HiQ putting together the VIAC portal that technical companies are very much alive to the risks that are there from a security aspect. And for example, the VIAC portal has a two-factor authentication login and all of these various aspects that make it extra secure. And I think once we bear that in mind moving forward, these are very positive developments.
Thank you, Niamh. I would like to stick to the contrast of digital communication and hard copy communication. I'm sure that you see a lot of examples and instances in your daily work. I would like to come back to the possible requirement of hard copy notification, in particular of the notification of an arbitral award. Do you see any legal requirements as to the formal requirements of the notification of arbitral awards? And would that be a reason not to communicate electronically, for instance?
Absolutely, Valentina. So obviously, the overall aim is that we become paperless in reality. However, there's always exceptions to the rule. And you mentioned the service of arbitral awards, but also actually, if you go back to the beginning of the case, the service of the statement of claim is also something that has to be particularly handled with care. So the VIAC transmits the statement of claim to the respondent with exhibits in hard copy form. So that's one of our exceptions to our electronic rule, and that is in order to obtain a record of sending in the form of a return receipt or other confirmation of transmission. And that is particularly relevant for what you mentioned, the enforcement of the award, particularly in a case where the defendant may subsequently cease to participate in the proceedings. It's extremely important for us that we have a confirmation of receipt of the statement of claim. And then as regards the service of the arbitral award, if it's not possible or feasible to send the award in hard copy, we may send it in electronic form. However, a copy of the arbitral award will always be sent in hard copy form because of the enforcement implications for a party at a later stage. And also because we are maybe not aware of the specific requirements in the specific jurisdiction where the award will later be enforced. So those two are kind of the exception to the rule. So I think we can, in general, say we aim and strive to become as digital as possible, but there will always be exceptions to safeguard the parties whereby we have to do things in the old-fashioned way, so to speak.
I'm sure Christian has also a view on that regarding the electronic communication in contrast to notification in hard copy, particularly of the arbitral award, but also of other legally relevant documents.
You have in an arbitration two particularly relevant moments. First of all, as Niamh quite aptly put it, the moment where the statement of claim has to be served on the respondent in order to guarantee this party's right to be heard. And then, of course, the service of the arbitral award, where also hard copies, I think for a number of years, will still be necessary in order to enforce those awards globally under the New York Convention. I mean, you would have to read quite some futuristic elements into the New York Convention to argue you could do it entirely without hard copies. Now, also, this is, I think, something peculiar for arbitration, or probably a difficult area of arbitration when it comes to service of claims, service of documents. Of course, the parties are free to agree on a certain way of service, but you don't have any really harmonized rules, and it's probably less critical or less complicated than in state court proceedings, because you can say, well, if the parties in their arbitration agreement refer to arbitration rules that contain provisions on service, this is what they agreed upon. But of course, as an institution, but also as a claimant, you want to make sure that respondent really received the documents, so that you not reach a decision that is later not worth the paper it's written on. In state court proceedings, it gets more tricky, and particularly when it comes to the need to service documents in cross-border cases. On a European level, it's easier because we have the regulatory framework for cross-border service of documents, even when it comes to electronic service of documents. When you look at the new European service regulation that will enter into force this year, you have a specific Article 19 which deals with electronic service of documents. This is, of course, restricted to the European judicial arena, and more difficult when it comes to the service of judicial or extrajudicial documents to third countries. There, I think it will still be very difficult in state court litigation to merely rely on electronic means of service. So I think there's still much room for development in the future in this regard. There is one question I would be interested to hear your views on, whether you should make a differentiation between different forms of hearings, like the organizational hearing, a hearing that is mainly there for planning the arbitration, for exchanging legal views, probably on a preliminary level. Is this something that will, in the future, or as it currently is, be mainly conducted virtually? And does this, in your view, affect the ability of parties to conclude a settlement? And do you think it's more difficult in a virtual setting to reach a settlement than it would be if you meet in person? Or is it also, with regard to settlements, is it equal in-person hearings and virtual hearings?
That's a very interesting aspect. Maybe Niamh, you would like to comment on that?
Sure, I think it's a really interesting question. And in my experience, generally these organizational hearings, so your classic case management conference at the outset of a hearing, depending on the size of the case, I would say if it's a smaller case, it has traditionally actually already been held in some kind of a virtual format, even before the global pandemic. Maybe larger cases with more individuals would tend more to have taken place in a physical format. So maybe that's just to the format of the hearings so far. And then as regards the question of settlement, I think that's in particularly an interesting question, because the new Vienna rules now expressly provide the arbitrator with the possibility to encourage the parties to reach a settlement, which wasn't allowed for before. And in my personal view and just in my experience, I think it does make a huge difference whether the parties are there in a virtual format or a physical format when it comes to the option of settling. I think realistically, it's more likely for a settlement to be reached in some form if the parties are physically in the room together, because there are so many aspects that play a role there. The body language and, that sense of being in a room with another individual is not there. Any emotions that the parties might have may be lost virtually. So I think that's something that should really be addressed by institutions, but also by counsel with their parties, to say, if you realistically have a vested interest in settling your dispute at an early stage, then we should push for an in-person hearing.
If I may add a comment from my practical experience during the past 2 years, I think the pandemic and the requirements that we were forced to act under the pandemic has increased the somehow habit that organizational meetings or hearings at the beginning of an arbitration are usually done virtually nowadays. So even if there were a factual possibility to come together for a case management conference at the start of the arbitration, I think in most cases we would now conduct such a case management conference remotely. My impression is that this COVID-19 pandemic has enhanced and reinforced this practice. However, I think it is a general perception, and I'm pretty sure that Niamh will confirm this, that most of the parties and the arbitrators have a strong preference to have a hearing where witnesses and experts are heard and questioned, to have such a hearing in person, just to enable and to facilitate the human interaction of such a hearing. As to the second aspect that was raised by Christian regarding the possibility of a settlement, in my experience, a settlement would rarely take place in the immediate context of the case management conference itself. I think the case management conference is a good opportunity for the parties and their counsel to come together. And I think the organizational conference at the beginning of an arbitration is a good opportunity for further steps onwards for the parties and their counsel to get together without the arbitrators if parties are really interested in settling their case. This is a good point to close our podcast, which is organized by the disputes practice group, meaning that it's a good point to come to an end when we discuss about settlement of arbitration and even litigation cases. I would like to thank our two distinguished speakers, Niamh Leinwather from the Vienna International Arbitral Centre and Christian Koller from the Institute of Civil Procedural Law at the University of Vienna, for taking their time to be with us today and to share their valuable insights with us today. Thank you very much. Hope to speak with you at some other occasion again.
Thank you, Valentina, for the invitation. It was a really enjoyable morning getting together with you and discussing these various issues.
Thank you very much also from my side. I'm very grateful. I'm very keen to see how the future develops. Probably there will be a gamification of proceedings and we will all sit there with our 3D glasses on. Who knows what the future will hold? And looking forward probably to discuss it in another podcast. Thanks for inviting me today.
Thank you for joining us for this episode of the Wolf Theiss Soundshot. For more information, you can contact us via email at soundshot@wolftheiss.com or visit our website at www.wolftheiss.com. You can also follow us here to receive further updates on developments in law and business from one of the leading law firms in Central, Eastern, and Southeastern Europe.